else for us?
Have you had an opportunity to review the requisitions?
So moved.
And yes? Okay, so who is up first? Don, or Judge Oda, are you presenting today, or you're just here in the peanut gallery to?
I think this is Mrs. Strasky's show.
You're in the amen corner? All right, welcome.
Good morning.
Good morning, how are you?
Good, and yourself?
I'm great. And would you mind just stating your name and address for the record, please?
Yes, ma'am.
Thank you.
My name is Andrea Ostrowski. My work address is 20 South Main Street in Springboro, Ohio. I am here on behalf of the Warren County Bar Association. I stood before you just over 2 years ago, right on the eve of COVID, really hitting and shutdowns and uncertainty about the economic future of Warren County, lawyers, court-appointed list attorneys. I don't believe that the commissioners ever made a final decision on the request at that time. And so the Public Defender's Office has continued to encourage local bar associations to pursue the requests. And so myself, on behalf of the Bar Association, along with some select committee members, have been working diligently to bring the matter back before the commissioners. So the Public Defender's Office from Columbus reimburses Warren County for court-appointed fees, and they have projected in their budget that they will continue to reimburse above 90% for what Warren County spends on court-appointed fees. Warren County has not increased the hourly rate or the caps since 2000, and the Ohio Public Defender's Office is making a move to get quality representation and to encourage attorneys to do court-appointed or public defender work. And so they have put forth guidelines and schedules for court-appointed work. So the Warren County Bar Association has passed another resolution encouraging the Warren County Commissioners to adopt a new schedule. That schedule has a couple different parts to it. One is the hourly rate. Currently, the hourly rate is $50 for out of court and $60 for in court. The public defender and the Warren County Bar Association is asking for $75 flat in court or out of court. Then, as a subset of that, there are these official caps that the public defender will reimburse and thinks that up to that value is could potentially be quality representation for court-appointed counsel. I do have a small handout from the county commission, from the Ohio Public Defender's Office. May I approach?
We've got it, I think.
Well, this sets forth the schedule.
Okay.
Yeah, that'd be
So,
great.
I don't know, you have a memo, but I don't know that you might have this.
You
So,
can bring it up, we're not that.
Judge, would you like one?
Yes, please.
Okay, thank you so much.
Yeah.
Thank you.
Thank you. Thank you.
Thank you.
I'll give you one for that. Does anyone else need one? Mr. Nolan, do you need one? Mr. Nice, would you like one?
Sure, thank you.
Would anyone over here like one? All right. So a subset of the hourly rate then becomes these caps. And so what we are asking for is that you adopt the caps that are set forth in the maximum fee schedule. The county commissioners set the county-wide maximum fee schedule for common pleas court, juvenile court, and misdemeanor courts, and along with the appellate court proceedings. So this sets forth the maximum that somebody could apply for and that the public defender would reimburse for. Of course, if there was extraordinary fees, that would be up to the judges. I know that there's a local rule in common pleas court for the criminal division that you can, if you go above $500 for what's considered a standard case, you have to submit a letter to the judges, and they would review that because they know how their cases are typically handled given their docket. And the Bar Association is not opposed to that remaining a local rule. We know that the judges are going to propose a lesser standard for maximum fees. I will tell you that Butler County, and I believe a majority of Hamilton County, has taken these fees and adopted these as the maximum. I know that the judges have done a mathematical calculation based upon the old standards, which did not meet the public defender's standards even back in 2000 when they were adopted, and then has just slightly modified them. So on behalf of the Warren County Bar Association, I'm asking the county commissioners to pass a resolution that would be for all court-appointed work in Warren County for an hourly rate of $75 in and out of court, along with the maximum fee schedule that is set forth in this exhibit from the Ohio Public Defender's Office.
I don't think you're going to have any opposition in the increasing of the hourly rate. 22 years, quite a while. I think we've done okay with that, but now, yeah, if we've got any information on this maximum schedule, I mean, that's the only open topic, but yeah, thank you. I think that, yeah, it's good with us.
Yeah, I just saw Judge Oda's email for application that the judges had approved it for the criminal division, if I recall correctly. Is that the nature of your request, is contained to or constrained to the criminal division? Or are you looking for for others, juvenile court, for example?
Right, I'm looking for a countywide adaptation by the county commissioners. And there was a email circulated, at least to myself, because I'm on the juvenile court appointed list, that Judge Kirby has recognized that there is some increase as well with the hourly rate, along with his caps that he is proposing in his court. So I do believe that Judge Kirby has also, Judge Joseph Kirby for juvenile court has also recognized the need to increase the hourly rate and the cap, which is why I am presenting to you the Ohio Public Defender's schedule that covers appellate trial work and misdemeanor work, because it needs to be countywide.
So Judge Kirby, what I'm looking at here is from Judge Kirby conforms to your request.
It conforms to the request in the terms of that he does recognize $75 an hour. It does not conform to pages 14 and 15 of the Ohio Public Defender's fee schedule, because once again, he's taken the old fee schedule and the old caps and done only a slight modification of that, and has not fully adapted the fee schedule as set forth and proposed by the Ohio Public Defender's Office.
And so can you share with me I can infer that the caps, when you increase the hourly rate, you have a sense of what the average number of hours are for a particular type of case, that frustrates the purpose of an increase in the hourly rate if the caps aren't raised simultaneously. Is that?
That is correct.
You're suggesting?
That is correct. And the Warren County caps did not comport and follow the recommendations from the Public Defender's Office even 20 years ago. So what Warren County is proposing to do is to keep undercutting what the Ohio Public Defender proposes and what they believe is a good maximum cap rate. And while judges and individual judges can give extraordinary fees, there are some judges that is very hard or non-existent to get from. And so some judges really do stick by what these maximum caps are, and therefore setting the cap is also important to court-appointed counsel. Because this is the maximum that the Public Defender's Office will reimburse the county for, up to whatever that percentage is. And like I said, they were above 90% for the last few fiscal cycles, and they're projecting to remain above 90% moving forward. I recognize that is subject to budgets in Columbus that I am not at all involved in.
That, of course, was the conversation we had when you were here, a couple of years ago.
Yes.
Was my concern is that we've been, I think that this is a state issue, frankly, and the state should pay for this, and it should not be on the counties to do this. Having said that, the counties fought really hard to get that allocation, which is we're already starting to see kind of be devalued over time, and we're going to head into another budget, and so hopefully we'll be able to maintain that. And then I realize that is not your issue. That is our issue. But that is always the concern, it's the same situation that you're putting before us, which is when you raise the hourly rate over here, but you don't raise the caps, you're not really advancing the ball. Similarly, when we get resources from the state over here, but then, spend it, that deficit still remains. So, look, I think that this is reasonable, and I personally don't have a problem with raising the caps. Our colleague, Commissioner Grossman, is not here, who I guess I should say is excused because his mother-in-law has passed, and so he was out last week and this week, and he may have more to offer on this conversation, so I hate that he isn't here. Dave, do you have any?
Well, there's two questions, right? Number one is the hourly rate going up to $75, hasn't been moved in 22 years. I've got personally no problem with doing that. Then there is a separate question of the maximum fee that's involved, and is that going to go up some, or does it go up to what you're recommending versus does it go up some, or is that flat with what the judges are recommending? That's the question.
Yes, Your Honor. I'm sorry. I'm just Judge
Come
Oda. It's 9 to 5. That's what comes out. 9 to 5 is.
I mean, look.
Well, if Bruce McGarry was here, I would remind him I got an A in constitutional law. So I play an attorney on TV, but I'm not one. But.
Yes, Commissioner. That is
Thank
that is the nature of the question. Like I said, understanding that judges are going to set it as they see fit, and they've done this mathematical increase to kind of mirror the increase in the rate. But I'd just like to point out that I think the Ohio Public Defender is saying that, these are the caps that they believe are appropriate, and that is why I'm asking that you follow along with that schedule and not just go along with what the judges have set forth.
Just tee it up. I mean, we can do that because he probably does that
Yeah.
a lot.
Yeah, so I guess what I would say, well, first of all, I would ask, since our prosecutor and Judge Oda and our auditor are here, if they have anything they'd like to add to the conversation, we certainly would entertain that. I think that we hear you, we're empathetic to your concerns, but I feel like, and Commissioner Young agrees, that we would like for Commissioner Grossman to have an opportunity to be able to weigh in on this, too. But I think he'll be back next week. So I'm not saying delay it 2 years. I'm saying that we'd like to delay the decision a week or so. But like I said, is there anybody else who'd like to weigh in on this issue?
Thank you very much.
Yeah, but thank you. And
So I
so
just
yeah,
want-
question number one, I would say, would be a yes. Question number two is open, and yeah, we'd like to have Commissioner Grossman's input on that.
Thank you.
Thanks.
Thanks. You nobody feels obligated to speak. I just want to make sure you have a chance to. I've read your memo or your email, Judge, so I'm not trying to put you on the
Good
spot.
morning, Your Honor.
Welcome, Commissioner. Oh, I mean, Your Honor.
So I think and I don't speak for juvenile court, Judge Joe Kirby has his own set of budgetary issues that he has to deal with. And I think the caps are much more important to Judge Kirby than they are to us in the general division, meaning the criminal division. I think the way the judges look at this is the vast majority of our cases in criminal division are resolved by a plea agreement. There are cases that go to trial, and I think those are very different. The public defender's office represents, I believe, somewhat of an urban vision of how this operates. In Warren County, we set every case, our criminal cases, we give a person a time to be here. So I have a case set at 8:45. I don't have 20 cases set at 8:45 or 40 cases set at 8:45. We have 2, maybe 3, like today when I had a meeting to come to. set, so we have a more, shall we say, measured approach to the use of our public defender's time, and by way of that, our taxpayer money. I think that the caps that the judges put forth is what I believe an average case that goes to trial should be. Now, there are cases that, such as Mrs. Strowski's most recent case, a murder case, that is a case that she submits an application by local rule. The judges consider that if it's 25% over the cap, as the trial judge, I can approve that by myself, or if it's over that, then the judges as a group decide, a majority of us, whether to pay a particular bill or not. Most of the time, we defer to the trial judge because they know more about the case than anybody else. But my concern in raising the caps is that a case that involves, we'll call it a moderate amount of unpleasantness, there needs to be a tipping point by which we say, okay, Mr. Attorney, if you're going to take a felony one case, this is what you can be expected to pay for, again, just a moderate amount of work in the case. By separate rule, and some people think of this as a cap, but it is not a cap. If your fee is in excess of 10 hours for a case that is a plea, you just need to put me a written explanation as to why that is. It's not a cap, and it's not a per se cap, but the judges have looked at this, and if you put more than 10 hours into a plea, there might be a reason for that, but most of the time, we need to look at that more critically. So that's how we approach these issues. I don't really care that much about what the caps are and how it's paid, as long as everybody pretty much has a good understanding of what it is. It's your guys' job to allocate the money. Our principal, and you will notice that the caps at the top, and I don't know if it matters to you, whether it's murder and sentences that carry with it a life sentence, those were a little out of whack. But the odd part about it is the more serious the case, the more it is likely to be resolved by plea arrangement. We don't usually try a lot of those cases, maybe a couple of a year. And I think that the judges are receptive to, okay, this is the amount of work that I put into this case, and then it is accurately reflected in what it's going to cost. I think that historically we have looked at this as not necessarily a revenue generating experience for the attorneys, although they do need to be paid for the time that they do. But we look at this as, and I know that this is a public service that attorneys do for their community, and also we want to try to push younger, less experienced attorneys into doing this sort of work so they will become more experienced attorneys. I had Chase Kirby, who was 2 years out of law school, tried his first case with me. Somebody who was out of law school only for a year or so, they would never have the opportunity to take a felony case to a jury trial without the court-appointed list. So I'll answer any questions that you might have, but I know Judge Teep wanted to be here. He is stuck on the bench, and I got in front of him with the deputy, so he's probably still on the bench now.
Maybe we, with Judge Kirby wanting to weigh in too, let's just
Yeah,
pick a date over the next couple of weeks where everybody can be here.
dun, 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 right on cue. Right
Yeah,
on
we
cue.
can,
Yeah,
But I know Judge Joe Kirby is out of town this week. He's in some kind of
yeah,
training.
so maybe we could look at, do you have access to the schedule? No.
maybe May 31st, probably, I think next week
So-
is pretty packed prior to your.
Yeah, why don't they
on the 13th.
get with their administrator, the judges, and we'll just schedule something and
Yeah,
put it
we'll
on.
schedule something as soon as we can to make a decision, and certainly we'd be happy to chat with anybody offline who wants to chat about it in the meantime.
Is it not the commission's preference to split this and just go ahead and approve the general criminal division where there doesn't seem to be much dispute, or? you want to do
I
it
hear
all as
you.
one big thing.
I hear you.
I mean, it doesn't matter to me,
Yeah.
it's just,
Yeah, if we're gonna wait for Commissioner
I
Grossman,
think
might
we
as well
should
wait.
just meet, but
Yeah.
we're just gonna wait a couple of weeks.
But yeah, but we want to give the person that brought it before us that, yes, the rate will go up. You know, we're, two of the three of us are saying, yes, that we're confident on that, and then there's just this open question, so,
any other questions of me?
thank you.
Thank you, Judge.
Thank you, Your Honor.
Good seeing you, Commissioner.
Anyone else wanna weigh in on this?
Do we have a date that this will become effective?
We don't yet because our clerk is out, but we'll get it scheduled in the next couple of weeks as soon as our clerk can.
You're saying the rate, the $75 rate? Could we act on that?
Yeah, we could.
Yeah, we can affect that immediately for you guys, if that's helpful.
Do you want to do June 1st for the rate increase?
Sure.
That would make it a little easier. Yeah, it would help.
Okay.
To do June 1st, that's 2 weeks.
Okay, is there a motion, to, raise the hourly rate as proposed?
I'll make a motion to raise this rate to $75 an hour for in and out of court for,
They're both the same for juvenile court, juvenile probate, and for the common pleas court to $75.
that is my motion.
And yes. Okay.
Morning, Sheriff.
Good morning, sir. How are you? I'm here, I had made the motion actually in the Bar Association to bring this back before the Board of Commissioners in support of, and it seems to be a little bit moot at this point, in support of the hourly rate increase. Obviously, our office has a vested interest in making sure that counsel that are handling cases that we are prosecuting are adequately prepared to discuss those cases, whether it's an issue of plea or whether it's a situation where they go to trial. I agree with Judge Oda. In Warren County, I mean, we just don't see a ton of jury trials. I would say, I would estimate maybe, or trials in general, in the common pleas division, maybe 36 to 40 a year. Is probably a good estimate. So as it relates to the second question, I would tend to agree with Judge Oda in terms of allowing that to be a local question. I'm not going to weigh in on what the appropriate cap is or not. I don't think it's necessarily appropriate for me to say how much defense counsel should or should not be capped, if you will, on how much they're spending on those cases or how much they're paid for doing so. I do understand, having practiced in Hamilton County in the municipal court and common police court down there, in the criminal dockets, as well as Warren County, we are substantially more efficient in how we handle our cases as compared to the cattle calls that you see down there. So I do think there is a benefit to weighing the judge's input with respect to these cap situations. I will say, as an officer of the Ohio Prosecuting Attorneys Association, as it relates to the issue of the reimbursements at the state level, there seems, for what it's worth, and this is more anecdotal than it is, actual evidence, I would say, there does seem to be a greater push at the state level to adequately fund public defenders. And so I would think that going forward, it would at least seem, from our experience at the Ohio Prosecuting Attorneys Association level, that you're not going to see a reduction in terms of the percentage of funding that you're going to receive as reimbursement for these types of expenses. So from my perspective, I think you again, based on what we're seeing at the state level, I would be very surprised if you saw a reduction in that type of funding in upcoming budget cycles, because that's not the way that the pendulum is swinging on this. Now, we all know that we're just, double-digit inflation away from all of that changing, but at least.
I've seen this movie a lot of times.
Yeah, I'm sure. Yeah,
Mr. Prosecutor.
I know, but the trend is that the trend continues to be that direction for what it's worth. Again,
No, I think you're absolutely right, and I would love for the state to assume their constitutional duty here.
Right.
I think that's perfectly appropriate, and we at CCAO continue to advocate for that.
Right.
In the interim, of course, we want to make sure that there is enough allocated by the state to be able to keep counties whole.
Right.
But
So I do appreciate, and again, it's a moot point by the time I got up here, I stood up here and you went ahead and made the motion, but my original point for being here this morning was to support the increase in
we appreciate
the hourly rate. And obviously, understanding, your overall expense is rate times hours. So if your rate goes up but the cap does not, I mean, you're basically increasing your rate 25%. So I would expect that you're going to see a 25%, at least I know there was a distinction between in-court and out-of-court, but you should expect to see about a 25% increase in your caps just based upon an increase in your rate. So I don't know if that's the way that the commissioners are going to evaluate that, but I would say
We
you
will
would at
debate
least.
that on our
Yeah.
next session
Yeah.
with Commissioner Grossman.
Okay, thank you very much.
Thank you all.
Thank you. So we'll bring it back up with a mutually agreeable time.
Can I make a request? I'm sorry. So I heard the motion, which was $75 for common pleas and juvenile, but you're leaving out appeals and misdemeanor work as well. So you're putting the county at different hourly rates for depending upon what court and what type of work they're doing. And so I just want to make sure that that is being addressed or at least being acknowledged by the county commissioners. Because my request is for all the courts that get court-appointed funds through the public defender's office to be at the $75 rate. And I don't mean to put Mr. Nolan on the spot for this, but I do believe that that does cover.
Yeah, we just received input, though, from those two, well, for the judges in the criminal division and from Judge Kirby. That's why we did it that way. But, Matt, did you want to?
I do apologize, Mr. Nolan.
That's not that we wouldn't address it. It's just, I think we felt as if we could move forward with those since those courts were asking for that.
Our request from the auditor's office would be for it to be $75 countywide. We're going to make these similar requests to Franklin, Lebanon, and Mason Court as well to keep it, because a lot of these attorneys jump from court to court, and if it's a matter of going by and figuring out which court's which and who's paying what, that's going to become fairly onerous on our staff. So our request would be $75 across the board.
Fair enough. I'll make a motion to adjust my motion.
To cancel the motion and a new motion?
Re-motion my motion to, across the board, $75 for all of these fees. Thank you.
And the only other point I will make, the reimbursement rate is at 100% now. It's been at 100% since April of last year, and we get a notice every month from the state. We anticipate it being at 100% for the foreseeable future.
We'll see.
Thank
Just a
you.
minute. Thank you. Yeah, we'll get you all back in. Thank you all for coming over. So we'll reschedule this.
Thank you. Michelle, I don't know if,
How much time do you need, Michelle?
Give me 2 minutes.
All right.
okay.
Okay. 2 items before you. The first is a new software system. We have been working with Matt Nolan's office, and Auditor Nolan was unable to because he had somebody retire and they've had other issues. He needs his own system, so he told us to look at the private sector. We have a company that we think is fabulous. We contract with Clinton County, City of Franklin, City of Lebanon. They all use this system. So we just need your approval to contract with iWorks in order to be able to use the tablets. We purchased those a year and a half ago.
And is it within your budget allocation?
Yes, we are able to cover that, yes. And then also the second thing would be, we would like to schedule a public meeting for fee schedule increasing. There's a couple of things that we don't even address, such as electric car chargers and solar array fuels that we don't even address.
And so you're just requesting a public hearing to raise your fee schedule?
Exactly, just to discuss that.
Just to
Okay,
keep
so
this more
we
current.
will need to confer with Tina when she gets back to get that scheduled, so.
We do have a resolution. We can confirm the date tomorrow if you adopt the resolutions for both of these items.
I'll make a motion to move forward with both of these.
And yes, and yes.
Did you do clerk general?
We did.
Yes.
Thank you so much.
All right, thank you.
Thank
Thank you
Thank
so
you.
much.
Motion.
Go ahead.
Motion to adjourn.
And yes.
All right, thank you.